Welcome to Part 2, Chapter 7. In this lecture, we continue to explore the hotel-guest relationship, and today we're going to talk about the guest's right to privacy. Our discussion today will be based in statutory law, common law, and contract law. Our competencies focus on access by third parties, protections against unreasonable search and seizure, and the guest's right to privacy. Let's start by examining how contract law plays a part in our conversation. We've already established that the process of renting a room creates a contractual relationship between the hotel and the guest. I think the easiest way to understand the basis of what we're going to talk about today is to relate the renting of a hotel room with something a lot of us have done at some point in our life, namely renting a house or an apartment. If you think about it, whether you rent a house, apartment, or hotel room, you're essentially doing the same thing. You're creating a contract to use a portion of another person's real property for a specified period of time. Once that contractual relationship is created, the statutory law kicks in and imbues the renter with a certain number of the same rights they would have if they owned the property themselves. Specifically, for our purposes today, the renter of a house, apartment, or hotel room gains the constitutionally protected right to a reasonable expectation of privacy under the Fourth Amendment to the U.S. Constitution. Most of us are probably familiar with the Fourth Amendment's protection against unreasonable search and seizure, as it applies to the places we live, like apartments or houses. But you might be surprised by the fact that those same rights extend to hotel rooms. Now, if you've rented an apartment before and taken the time to read the lease, you probably noticed that the owner of the property usually reserves the right to enter the premises under certain limited circumstances, usually with advance notice, to check on the property or do maintenance or show the property to prospective renters and things like that. Other than that, we expect our apartment to be our own private space. The same concept applies to hotel rooms. We don't expect anyone else to enter that hotel room while we are in there except for things like housekeeping, service, or maintenance, right? I mean, imagine if you're sitting in your hotel room watching TV and the manager let herself in with the master key. We'd be pretty upset, wouldn't we? So let's take this concept a step farther. If the landlord, or in our case the hotel manager, doesn't have the authority to just walk into the space we've rented anytime, it follows that they can't grant anyone else the ability to do so without your permission. We said we'd be upset if the manager used a passkey to barge in, and that wouldn't change if the manager gave that passkey to someone else, would it? No, of course not. The bottom line here is that once we have a contractual right to occupy the space, we also have the right to grant or reasonably limit access to that space. Now, this is the first time this semester, but certainly not the last, that we will talk about the hotel's affirmative duty to protect the guest, or in this case, the guest's right. Specifically here, I'm referring to the hotel's affirmative duty not to allow unregistered or unauthorized third parties access to guest rooms. Let's take a look at a few cases in your text to illustrate this point. In the case of Campbell v. Womack, the court affirmed the right of hotels to refuse unregistered persons access to a hotel room, even if that person is the registered guest's spouse who has been in the room previously. In this case, the husband had rented a room for an extended period of time in his name only. The wife had visited in the past on weekends, but was not a registered guest. At one point, she came to the hotel without the husband and was refused a key or entry to the hotel room. The court sided with the hotel because of the hotel's affirmative duty to protect the privacy of the registered guest. In the case of the City of Strongsville versus Patel et al., we see just how far this protection extends. In the Patel case, the court dealt with law enforcement's limited right to view a hotel's guest register. Now, when you read this case, you might be a little confused at first, but if you view it in light of the protections granted by the Fourth Amendment, it should be a bit clearer. Think about the amount of information that can be gleaned from a guest register today. Your full name, your address, make, model, and license plate of your vehicle, your credit card number, the number of guests in your room. This is all information in which we have a reasonable expectation of privacy, and which the hotel has a duty to protect. Just as you wouldn't want the manager to let a stranger into your hotel room, you wouldn't expect them to give out your private information, even to law enforcement, unless they have the legal authority to gain access to that information. And that's a good segue into our next point. Again and again today, I've mentioned that we have a reasonable expectation of privacy, or put another way, we have a protection from unreasonable searches and seizures provided by the Fourth Amendment. In general, once a guest has a contractual right to occupy a hotel room, only the guest may consent to a search of the room. While hotel staff may enter the room to clean or conduct maintenance, they don't have the right to allow others, including law enforcement, to enter unless an exception applies. So what are the exceptions? If the guest consents, the search is reasonable. Second, the protections only apply during the guest's tenancy or while they have the right to occupy the room. So if they are past their checkout time, or if they paid for one night and are trying to stay for two without paying, then they no longer have the right to occupy the room. The same concept applies to the lease for your apartment, right? If you have a lease for a year and you stay for 13 months without paying, you would expect the landlord to try and evict you. More on that, by the way, in Chapter 8. Third, if the police have a search warrant, then a judge or a court has decided that the search is reasonable and therefore allowed. And finally, if there are some exigent circumstances, for instance, in a situation where the police hear screaming like someone is being attacked in a room, they can enter without a warrant. Again, the bottom line here is that where the Fourth Amendment applies, we have a reasonable expectation of privacy, and the hotel has an affirmative duty to protect that right. So that wraps up our discussion in Chapter 8. As always, if you have questions, please don't hesitate to reach out. I hope you have a great day.